Hello, everyone, and welcome to Health Justice in the Americas, the role of the Inter-American Court of Human Rights. My name is Carmel Shachar, and I am the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. I want to welcome you to this event. I think oftentimes it is easy to focus on individual cases and lose sight of broader trends and broader context. And I think this event is really going to do that, explore the broader jurisprudence of the Inter-American Court of Human Rights as it comes to the right of health, especially in the last several years. This is an event in which we really welcome your questions. We strongly encourage you to submit questions at any time using the Q&A feature found in Zoom. It's in the meeting controls at the bottom of your screen. You should, of course, feel welcome to join the conversation with us on Twitter or submit questions on Twitter at Petrie-Flom using the hashtag HealthJusticeAm. Again, that's hashtag HealthJusticeAm. On the other hand, if you have any technical issues, please email petrie-flom@law.harvard.edu, and we will do our best to help you. There will be a fully captioned event recording that we will publicly post within 1 to 2 weeks. If you like this event, please consider signing up for our newsletter. It comes out only twice a week. Sorry, not twice a week, twice a month. And it highlights some of the exciting events we have coming up. We also have our blog, The Bill of Health, which brings you cutting edge thought leadership on health law, health policy, bioethics, as well as we have a separate link for checking out our upcoming events. We are also so grateful for our co-sponsors here, including the Global Health Education and Learning Incubator at Harvard University, as well as the David Rockefeller Center for Latin American Studies at Harvard University. Please check out their web pages and all the amazing work they do. This event is held under the auspices of the Global Health and Rights Project, or as we like to call it, GRIP, which is a collaboration between the Petrie-Flom Center, the Global Health and Education Learning Incubator, GELI, at Harvard University, and the Andes and Southern Cone Program and Mexica Program at the David Rockefeller Center for Latin American Studies at Harvard University. Our moderator for this event is Alicia Eli-Yamin, who is the Senior Fellow in Global Health and Rights at the Petrie-Flom Center, as well as Senior Advisor on Human Rights and Health Policy at Partners in Health. Ali, I am delighted to hand the event over to you.
Thank you so much, Carmel, for that introduction. And I also would like to add my thanks to our co-sponsors and especially to the David Rockefeller Center that has done a great deal of outreach for this event, and we always enjoy co-sponsoring with them. So today we have really an extraordinary group of people who have all served as not just as scholars of the work of the court and the inter-American system, but they've all contributed to the development of that jurisprudence. And we're going to be exploring jurisprudence in specific areas, in sexual and reproductive health, in the regulation of private actors, in access to public health and healthcare entitlements, from emergency care to other forms of care. But we're also going to try to provide an overview of sort of how this jurisprudence has developed at the court. For that, you know, what I hope we get at is this quite extraordinary apparent paradox, which is that Latin America is a region where there's a broad constitutionalization of health rights and economic, social, cultural, and environmental rights generally, either directly in constitutions or through what's called a constitutional block that incorporates rights from international human rights treaties. including the American Convention on Human Rights and the Protocol of San Salvador when it's applicable, and others, the Belém do Pará Convention on the Eradication of Violence Against Women. And we have groundbreaking jurisprudence from constitutional courts that have really pushed the limits of soft form or dialogical remedies. And we have this very, very active and vibrant inter-American system of human rights with a court that has, as you will hear, issued some very landmark groundbreaking jurisprudence in relation to economic and social rights and health, informed consent, and other health-related questions. But at the same time, Latin America is known as a region with perhaps the steepest socioeconomic inequalities in the world, and inequalities along other axes of identity, such as gender and ethnicity and race. There are enormous pockets of exclusion in societies, from indigenous people to persons with disabilities to LGBTQ plus people. And it is also a region known for political polarization, regulatory dysfunction, and regulatory gaps in health, and compliance gaps, and in general, fragmented health systems, right? Fragmented health systems divided by employment status, fragmented health systems divided geographically, highly medicalized health systems that emphasize the commodification and medicalization of care and commercialization of health. So we're going to explore in that context the effectiveness and what has been the effect of this jurisprudence from the Inter-American Court. I'm hoping that we will also get to talk in some length about comparisons, right? Comparisons, as you'll soon hear, of the way this jurisprudence began to be developed, which is quite different, say, from the Committee on Economic, Social, and Cultural Rights of the UN, and the jurisprudence is quite different from the European Court of Human Rights too, which some would say has adopted a more proceduralist or a more deferential approach to margin of appreciation. And that, of course, all has implications for legitimacy and follow-up, et cetera. So I hope we get to discuss both issues in the region as well as some comparative issues with our extraordinary lineup of speakers today. And I'll now introduce those speakers. First is a longtime colleague and friend, Christian Curtis, who is now a senior human rights officer at the UN Office of the High Commissioner for Human Rights in New York. He has been one of the really people who has formed this field in Latin America, and is probably holds the record for how many times he's testified at the Inter-American Court as an independent expert. So we're absolutely delighted to have Christian. Then Laura Clerico, who is an independent researcher at the Argentine National Research Council, CONICET, and a professor of constitutional law at the Universidad de Buenos Aires, and an honorary professor for constitutional and comparative law and protection of human rights at the University of Erlangen-Nuremberg in Germany. Will follow Christian. Then we will hear from Liliana Ronconi, who is also a researcher at the Argentine National Research Council, CONICET, and holds a PhD in law from the Universidad de Buenos Aires as well. Finally, Diana Guarnizo, who has a PhD in law from the University of Essex and is director of the area of economic justice at the Center for Study of Law, Justice, and Society, known as De Justicia in Bogotá, Colombia. So I'm really absolutely delighted to turn it over to Christian. While they are talking, please, we very much encourage you, as Carmel noted, to send in your questions to the Q&A or through Twitter, et cetera. And we will be turning to the discussion and the Q&A as soon as everybody has spoken. Thank you.
Thank you, Alicia and Carmel, and thanks for the organization. Thanks also for the ones that register for this event. Good afternoon. What I will do is just present briefly a little bit the, you can skip that now, Laura. We start briefly with an overview of how this jurisprudence on health-related rights has evolved in the Inter-American Court of Human Rights. So some basics there. One is most of the litigation before the Inter-American Court of Human Rights is based on the American Convention on Human Rights, which is basically a civil and political rights instrument. Its two sources are the European Convention of Human Rights and the International Covenant on Civil and Political Rights. But the American Convention, which was adopted in 1969, included a chapter which has a single article on economic, social, and cultural rights. So to that degree, the comparison shows some more progressive approach of the framers of the convention, and part of the discussions around health rights have revolved in the last years on what has come out as direct application by the court of this Article 26 on progressive development. So if you have a look at this article, it's based on Article 2.1 of the International Covenant on Economic, Social, and Cultural Rights. But a striking difference there is that one is the overall obligation of the covenant that applies to all the rights that are enshrined in the Covenant on Economic, Social, and Cultural Rights. While this particular clause, Article 26, while copying the general obligation, it does not indicate which are the rights. It has this reference to the rights implicit in the economic, social, educational, scientific, and cultural standards set forth in the Charter of the Organization of the American States. So instead of listing the rights that are protected under this article, there's a reference to another instrument, another treaty. And for a long time, the court basically rejected claims based on Article 26, either saying that this was not a justiciable article, or it was justiciable, but it didn't merit, the specific case didn't merit opening a discussion on this particular article. So we'll see some of the discussions that come out of the court's change of jurisprudence. Next one. So timeline about the case law on health rights by the Inter-American Court. Interestingly, this turn of jurisprudence happened in 2017. So before that, and particularly since 2003, 2004 to 2016, most of the health rights, or all of the health right cases decided by the court, were decided in connection with other rights, deriving health right obligations from other rights in the list of civil and political rights. So that includes most of the cases revolving around the right to life and personal integrity, with the interpretation that these rights are not only negative rights, but also enshrined positive obligations by the state, including access to healthcare. But then there's there are other rights that were connected to health rights, protection of the child. So in many cases where children are victims, the particular clause on protection of the child has been interpreted as requiring access to health services, private life, and access to information. So as you will see, the cases regarding informed consent revolve around these two rights, and then access to justice, due process, and the right to effective remedies when violations impinge on health-related rights, framed as the violations of the right to life or to personal integrity. So in this long time, 12 years, many cases have been decided framing health right cases under other rights. Since 2016, the court changed its jurisprudence and started directly applying Article 26, as shown before. And I mean, one of the main discussions there are which are these rights that can be derived from the Organization of American States Charter. So since 2017, the first cases were on labor rights, but since 2017 till now, most of the cases regarding the right to health had been adjudicated as directly as right to health cases, as an autonomous right, even if not giving up the interconnection approach. So sometimes the analysis includes the right to life, personal integrity, and the right to health in connection with other rights. Next one. So trying to cluster cases, and this is independent or regardless of which was a basis for the adjudication. A number of the first cases were access to health and health services, even access to minimal health cases, health care services were brought forward by the court. Are cases where the connection of this positive obligations regarding a right to life and personal integrity were involved, and also protection of the children. And the court developed part of this jurisprudence in these three cases against Paraguay. One is a juvenile facility case with deaths of the minors that were inmates in this institution, and then two indigenous peoples communities cases against Paraguay, Yaquiax and Sahuayamaxa. This is a basis of the cases where the court derived right to health obligations, particularly access to health services, as a necessary component of the right to life and personal integrity. There are a number of cases regarding psychiatric commitment in mental health facilities. The first one is the first important case where, beyond the specific issue regarding so this Jimenez Lopez case from 2006 was a case where it's a case of a death of a patient in a psychiatric facility, but the court develops for the first time a long analysis on the idea that health is a public good, and regardless of who is the health provider, private or public, the state has obligations to regulate and supervise and monitor the provision of health services. And in this particular case, it was a private institution outsourced by the Brazilian health service. So the court says that this violation was directly imputable to the state because of the outsourcing. So it's the first case where the court makes this bold, strong statement about the centrality of state regulation and supervision of private actors. And then a more recent case using Article 26 is this Huachala versus Ecuador case, was for the first time the court analyzes the issue of legal capacity and links legal capacity and informed consent as a test for the legality of psychiatric commitment. Then before 2016-17, a number of cases regarding personal injury damages and malpractice were considered by the court. In these cases, the right to health was linked to the right to life and right to personal integrity, and particularly to access to just and access to adequate remedies. A number of cases revolved around this basis of regulation of the private sector, and two of them, one before and one after the application of Article 26. González Lluy is about the regulation of private blood banks, and Vera Rojas is about the regulation of private health insurance providers. A number of cases on sexual and reproductive health and rights, so Artavia Murillo on the prohibition of assisted fertilization treatment in Costa Rica. Ivy versus Bolivia is around the issue of sterilization, forced sterilization, and Manuela versus El Salvador, not Ecuador. Sorry, that's a mistake in the PowerPoint. Is about confidentiality in cases of obstetric emergency and the right to consent or not the disclosure of personal information, medical information for personal prosecution or for criminal prosecution. Next one. And then a number of cases decided after 2016 deal with the issue of adequate treatment and medication. One of the panelists will address this one. There's some cases before and after Article 26 on the issue of access of prison inmates to health services, and then a number of I told you about informed consent, and then a number of other cases regard issues of occupational safety and health health protection in factories and in the profession of divers in Honduras. Next and last, there are a number of issues arising from all these cases. One is the inclusion of this Article 26 discussion has made the court include issues regarding immediate and progressive obligations, and the way in which the court deals with this is not very clear. The court has avoided the use of minimum core obligations, so sometimes it's not very clear when the court is referring to immediate or progressive obligations, and in some cases these are conflated, and this is not very clear. The court has used the availability, accessibility, acceptability, and quality criteria as stated by the Committee on Economic, Social, and Cultural Rights, but its application is not always very clear. There are a number of interesting issues on the use of non-discrimination, special protection, and intersectionality in cases of gender, disability, children, inmates, and socio-economic discrimination that have been applied to different degrees in cases with different fortune. So that's issues to be debated. And then a number of new issues. There are a couple of pending issues which are interesting. One is there's a pending case that will be heard this year on environmental pollution and health. There's a big case of industrial pollution coming out of mining. And then there will be an abortion in case of non-violent fetus case. It's on El Salvador. And last point is there's a new court composition starting this year. There have been dissents on all the cases regarding Article 26. So there's 4 new judges, and we don't know whether the new judges will follow the majority opinion on Article 26 or not. So I think my time's up. This is
Thank you so much, Houston. That was really an incredible overview, and we'll come back to those open questions, I'm sure. Can I turn to you, Laura Clerico?
Okay, thank you very much, Alicia, for the introduction and also for the invitation. Also, Laura and Carmel, also thank you very much. And it's my pleasure also to share this space with Christian, Liliana, Diana, and the audience. I'm going to speak about 2 cases that were introduced by Christian. Poblete Vilches versus Chile and Cuscul Pivaral versus Guatemala. And I'm going to speak about the strengths and opportunities of each case. And first of all, I would like to come back to one of to the speech or the presentation of Alicia. Alicia presented the structural situation of the health system in Latin America and referred to the thesis of fragmentation. There is another thesis, a very basic thesis, that said that the structure of the health sector reflects social structures. So the influential groups have privileges that they have defended over decades, while the poorest communities have to deal with far poorer access and quality of care. These 2 cases that I'm going to present are examples of this second part of the thesis. They are members of these poorest poorest communities. In this sense, these two cases are not isolated cases. First of all, Poblete Vilches versus Chile is a case that it's about a poor man in a public hospital, and not only a poor man, but an old person in a public hospital, that he was a victim of public health care in Chile. This was something said by by his son, and it's like a summary of the case. Poblete Vilches, no, Vinicio Poblete Vilches, this old man, he was 76 years old. He has severe respiratory failure. He underwent surgery. He was not conscious, cannot give his consent, but nevertheless, at the same time, his family was not asked to grant to give such a consent instead of Poblete Vilches. Poblete Vilches had grave state of health, and he was discharged. But as you can imagine, a couple of days later, he was readmitted, and this time, he had no access to necessary medical services like a ventilator or access to intensive care unit. And one of the doctors of this public hospital told his son that Poblete Vilches, Vinicio Poblete Vilches, was too old and the hospital could not give him another chance. So Poblete Vilches died in hospital. It is also relevant to see that it's not an isolated case, although the court in some sense addressed as an individual case, because context tells us that other similar claims were presented against this public hospital. Which are the strengths of this judgment? First of all, as Christian told us, the court declared a violation of the right to health as an autonomous right, so a direct violation of the right to health. And in this case, the court addressed the case as a violation of state immediate obligation. That are these two types of obligation were introduced in the case: immediate obligations and progressive obligations. But the court said we are dealing here with immediate obligation, and how to determine that this is a violation of immediate state obligation? Well, we have this UN criteria developed in General Comment number 14 about availability, accessibility, acceptability, and quality. Then we see the concrete circumstances of the case, and we come to the conclusion that there is a violation of this immediate state obligation. Why I would like to highlight that, because this is an easy case in terms of methods of adjudication. It's very easy. It's some sanction. It's not something sophisticated, but at the same time, it's a tragic case. In lost opportunities regarding this case, the Inter-American Commission is party in the trial, sustained that this was an opportunity to examine the case regarding the situation of poverty, and not only regarding that Poblete Vilches was an old person, but the court did not want to address the case under the perspective of poverty. The court could have developed this the test of inequality, taking into account the interconnection or the intersectionality between age and poverty. But this was not the case. But in other cases, is the court is going to develop or to address to apply the intersectionality approach. So strengths and some lost opportunities. Let us turn to the other case. The other case is the Cusculpi-Varal case. Cusculpi-Varal case is about 49 victims that were living with HIV in Guatemala. 35 victims are still living with HIV, but 15 victims that live with HIV passed away. Why? Because they have no access to treatment and medicines. Again, an omission, a clear state omission, a clear state violation of an immediate state obligation. One aspect related to the context, Guatemala, as you can see there, and this was also a part of the merit of the decision, is the country with the greatest number of people living with HIV in Central America. So in the case, 49 victims, but as you can imagine, there are more in Guatemala. Highlights or strong points, again, these judgments reinforce that the right to health is an autonomous right. And in this case, the Inter-American Court apply an intersectionality approach to address the case. I'm going to say something about it. But again, the court also maybe again reinforce that we can use the general comment number 14 to determine the content of the right to health, and at the same time to determine if the state action, in this case, the state omission, means or not a violation of the right to health under these 4 elements: availability, accessibility, and acceptability and quality. Another important point of this case is that at the same time, the Inter-American Court state that Guatemala violated immediately state obligations and progressive state obligations. This is we can say a weak point in the merit of the judgment. The court did not differentiate it quite clear what is immediate obligation and what is progressive obligation in relation to the case, because theoretical it's clear, but not in relation to the concrete case, and come to this conclusion: these 2 violations of a state obligation. Well, lost opportunity in this case, it was not very clear how to examine the violations of progressive obligations. At the same time, you can tell me, well, but this was a very clear case because no public policies related to health access to health services to people living with HIV and medicines. And you are right. Maybe it was not the case to develop this methodology, but still this is something that the court has to develop. And well, reparations and warranties of non-recurrence. Well, I think the court order some warranties of non-recurrence, not only reparations related to implementation of public policies. And for sure, it is very, very important to see this supervision procedures that the court has to do, so as to see if the country comply or not with the order that is related to the to the public policy, because this is key for people that are still living with HIV in Guatemala and don't have access to health services and to medicine. So to close my presentation is to come back again to the thesis that opened my presentation, and to invite you to think about that, not that the problem of not complying with states' obligations in these cases is a way to reinforce the structure of the health sector that for poor communities it means to deal with far poorer access and quality of care. So these two cases, I think, are main cases because highlights the importance of complying with state obligations in regarding access to health care and medicines. Thank you very much.
Thank you very much, Laura, and I apologize for cutting you off. I think we will have a chance to discuss the health system as a reflection of broader social inequalities. Can I turn now to you, Liliana, to talk about cases on sexual and reproductive health?
Thank you, Alicia. Thank you for the presentation. Sorry, can you see? Thank you for the presentation and for the invitation. I want to talk about the sexual and reproductive rights in the Inter-American Court of Human Rights. My presentation had this point, but I talk quickly about the first two points. Alicia and Laura talk about the context where the health rights are violent in the regions, and I can add how is the impact in women's and LGBT a person. The context of the inequality have more impact in this person. And another point about sexual and reproductive rights. Sexual and reproductive rights are important for all people. The recognition is important for all people, but it's more important for women because the roles about maternity and about reproductive falls in women, specifically in women. About sexual right is this right protect, for example, sexual identity, sexual orientation, and the court of Inter-American Court of Human Rights adopt this concept about sexual rights. There are here Atala Rifo, Duque versus Colombia, Vicky Hernandez. There are cases, perhaps not specific about health rights, but in this case, the court adopt a very strong concept of the sexual rights. The first case, like Christian said, about the reproductive right is a case in the Inter-American Court, is a case Artavia Murillo versus Costa Rica, where the court need to talk about the prohibited in vitro fertilization in Costa Rica. In this case, the court didn't recognize the violence of the right to health, but give or held, for me, very important standard. The first standard is about the court held that the personal decision to produce biological children through in vitro fertilization were protected under the Inter-American Convention or American Convention, protected by privacy and familiar life. Another important point of this standard of this case is that the court held that the life is not an absolute right. Therefore, the court said the gradual protection of the embryo is compatible with the convention. And thus, for me, it's a very important point, and was a very important point in the region to, for example, when we discussed the abortion, the legal abortion, for example, in Argentina. Another point in this case is that the court showed the discrimination that the case applied for disability, for economic position, but the court say the prohibition of in vitro fertilization has a very impact in women, because again, the court say the roles associated with maternity and reproductive rights are connected with women. And for me, it's important show not only the standard of the Inter-American Court, so it's important to talk about the remedies or the reparation that the court adopt. And in this case, the court decided that the Costa Rica should authorize in vitro fertilization and to promote through the in vitro fertilization by the social security system. And here is important because the court don't talk about right to health, but use the right to health like a reparation. The second case is the case IV versus Bolivia. In this case, the court condemned Bolivia for the forced sterilization of a poor migrant woman who live in Bolivia as a refugee in the context of the birth of her second daughter. Here you can see the facts of the case. Again, the court don't talk about the right to health, but has a very important stand linked with the consent. And the court say that there is an international obligation of the state to obtain through its health workers the consent of the patient, especially in case of women female sterilization. And this consent, say the court, need to be prior, free, full, and informed. And again, this is a very important standard about the right to health. The court in this case talk about the discrimination for the special situation of the woman. She was poor refugee migrant of Peru, and the court connects the gender stereotype and forced sterilization. But the court in this case talk too about the power of doctor in general and especially in the context of the delivery. So in this, when the court describe the discrimination, include this specific power that the doctor has in general and in this context of the delivery. Again, about the remedy, it's important for me to describe how the court adopt structural remedies in some case. For example, in this case, the court obliged to the state to design a publication with the women's right, especially with the sexual and reproductive health right, and with a specific mention of the consent, prior, free, full, and informed. Obliged to the state to create an education and training program for medical students, medical profession, and health workers about consent, gender discrimination, gender stereotype, and gender violence. And in the third case, this case for me, again, in this case, perhaps it's not a specific case about the right to health, but in this case it's important because the court create a standard about the obligation to prevent sexual harassment against adolescents and girls in the educational context, and to ensure access to sexual and reproductive education. In this case, the court identified a lot of rights were violent for the state, but for me, this case is important in this topic, in the sexual and reproductive right, because the court established the obligation to the state to create safe educational environments with, for example, with protocol where women or girls can denounce the situation of violence, But in another hand, the court highlight the import of the comprehensive sexual education, and for that, the court take the concept of the Economic, Social, and Cultural Rights Committee, and the educational comprehensive sexual education need be scientific, without discrimination, and so on. So in this point, I think it's important. Education in general and comprehensive sexual education has this double potential. In one hand, it allows us, or is allow girls to identify situation of violence, but in another hand, the comprehensive sexual education it's a key to making another right effective, especially the autonomy. And that is important in the context where we have a lot of, for example, girls, teenage pregnancy, or there are unwanted pregnancy. I think the comprehensive sexual education is a tool to prevent this type of situation. And in this case, and in this case, IB case, the court recognized the importance of the health assist to the victim, in this case for the victim's mother, and obliged to the state to give psychological assistance to the victim. And the court say that it's not enough that the state have a public health system. The court say the state needs to recognize a real access to the public system. To the assistance. And the last case is Manuela versus El Salvador. In this case, Manuela was a poor rural woman who was pregnant and had an obstetric emergency. And when she arrived to the hospital, she was denounced by the doctor, and then she was criminalized and was sentenced to 30 years of prison. Manuela died in prison of cancer shortly after. Manuela has an obstetric emergency because she was an illness, but that was not when Manuela required assistance in the hospital. El Salvador has a legislation that the abortion is not allowed in never cases. And Manuela is only one case, but there are a lot of women in El Salvador who are criminalized for the regulation, for the strong regulation about the abortion in El Salvador. And in this case, the court identified the discrimination that Manuela suffered, but the first point
can you wrap up pretty quickly?
Yes, I finished in 1 minute. In this case, the court established a standard regarding to the professional medical secrecy, and the court recognized the effect of the absolute provision of abortion in El Salvador, but not declared that the El Salvador legislation is contrary to the American Convention. So the court explained the disproportionality of the rule, but don't talk about the abortion and the necessity of the regulation of abortion in some countries. So the case has another standard about stereotype and so. Perhaps the conclusion, I can say that the court speak to right to health, creates several standards about the right to health, for example, about the professional secret, personal autonomy, consent, and so. It's important to when the court talk about this case, the court look the context where these rights are violent, And perhaps I can finish here and then we can discuss about this point.
Thank you so much. And again, apologies for cutting you off. Can we turn to our last speaker, Diana Guarnizo, and then we'll be able to come back to some of these topics that have been raised.
Thank you. Thank you very much, Alicia, and all the colleagues, Christian, Laura, Liliana, for this conversation. I would like to focus, if we can move to the next slide. I would like to focus on the obligation to monitor and supervise the provision of healthcare services, particularly those provided by private entities. This is a topic that has been very important in the inter-American jurisprudence, and I would like to use these 10 minutes to explain a little bit more how has been the development of this obligation. So as Christian already mentioned, everything started in the 2006 when the court used the Article 2 on the American Convention to say that in order to protect rights, states have the obligation not just to suppress any rules or practices that are against the rights, but also to provide norms, to create norms, to develop practices that make those rights effective, and to make sure that those rights are effective in practice. So the following. Next slide, please. So in this case, the court used this article to say that all states have the obligation to regulate and supervise all activities related to the provision of public services in general, and that healthcare is one of those public services. Therefore, this obligation to regulate and supervise should be extended to the healthcare provision. And most important is that the court explains that this obligation should cover not just those healthcare services provided by public entities, but also for those of a private nature. And this is something that it will highlight the court very often in their jurisprudence. Using this idea, so we can say that after this case, states are responsible when they for the omission in this duty to regulate and supervise these private entities. This is something important that we will keep repeating in the jurisprudence. Following the next one, please. Then, in this case, the court also explains that this general obligation to regulate and supervise includes other obligations. The first one is obviously to create an appropriate legal framework, so the private entities understand exactly what are the obligations, what they have to do, etc. The other obligation is to create mechanisms to carry out inspections and in general to investigate and to solve complaints. Then the court will go in more depth in this obligation to say that in general it has a general obligation to investigate, to sanction, and to also to report the violations that are committed against people or against victims. Next one, please. So as I said, since 2006, the court has been using this idea of the general obligation to regulate and supervise, which is also repeated in the Alban Cornejo case, which is related also to the to some malpractices that were carried out in a private hospital, and in this case, the state of Ecuador was found responsible for omitting this obligation, for omitting to supervise and regulate what was happening in this hospital. In this particular case, for example, next one, please. in this particular case, for example, apparently this person who was admitted to the hospital for a minor illness died one day after for a medical malpractice. And besides, the state initiated a investigation, a criminal investigation. This led to a criminal statute of limitation because there were no proper laws that that frame this kind of cases in the country. So after this case, the court declared that the state did not comply with the duty to regulate and supervise, and therefore there was a violation of the access to justice and life, because remember, at that time, the right to health was not directly found as part of the protected rights in the convention. Next one, please. So this one, then in 2015, is this very important case, Gonzalez-Lluy versus Ecuador. And I say this is important because in this case, the court explains how the supervision and monitoring should be. In this situation, what happened is that a girl, 3 years old, received a transfusion of blood, but the blood was contaminated with HIV. So therefore, she developed the illness. And the problem is that at that moment, these blood banks were not controlled by the state. The state had delegated the task of managing the blood banks to the Red Cross, which was a private entity. But the court is very clear that in this type of situation, the states have the obligation to monitor and supervise by themselves, and that they should have not delegated that obligation in any private entity, such as, for example, the Red Cross. Next one. Then another important case comes in 2021, which is the Vera Rojas case, in which a girl, again, but this time with a chronic degenerative disease, required to receive home care. But in that situation, the family had a private contract with a health insured, and by unilateral decision, the insured all of a sudden decided that the girl shouldn't receive home care anymore, and that they should go to the public service. And obviously, the public service didn't have enough provisions to take care of the girl. So in this case, there was an investigation, and actually there was a judicial decision that said that this decision from the private insured was arbitrary and discriminatory. The problem is that besides this decision happened within the domestic
Diana, you froze. If you can hear us. Diana, if you can hear us at all, maybe turn off your video and try doing it that way. Okay, I think maybe we should go to the discussion and allow Diana to finish the presentation later. So there are already a few questions in the chat, and I might try to enhance some of them to give to all of you or some of you. One comment question is, it is remarkable to see that there is clear jurisprudence in the Inter-American Court of Human Rights with regard to the right to health. Oh, Diana, ya estás.
Hello, I'm here again, but what happened, Sophie, with my internet?
So you froze for a few minutes. Should we go back to your presentation, or should we go to
yes, please.
Okay, all right.
Yeah.
Okay, that's
not
fine.
sure what was the last slide and the last time that you
So if you could just wrap up Vera Rojas quickly, because we're running out of time for the discussion.
Okay, so as I said, in the Vera Rojas case, it was good for the state to have this domestic decision that found that the decision of the insurer was arbitrary and discriminatory, but the court said that this is not enough. The state should make sure that the victim can actually access in an effective manner to the health service that is required, and also that the state have a duty to repair in those situations when the people cannot, for any reason, couldn't be able to access to the health service required. Next one, please. So just to wrap up, I would like to also refer to this also very important duty to prevent disabilities and to rehabilitate victims. This is something that has been developed also very recently, particularly in this case, Buzos Mosquito versus Honduras from the last year. In this case, related to indigenous community in Honduras, they were doing some type of underwater fishing in order to subsist and to make a living. But very quickly, this became an extractive industry, and many people from this indigenous community died and disappeared. Some others developed some illnesses and disabilities for the type of diving that they were doing when performing these fishing activities. So in this case, the court explained that that when protecting the right to health, and again, remember here that at this point, the right to health was already directly protected by the jurisprudence of the Inter-American Court. The right to health implied not just access to health service in general, obviously with the standards of availability, accessibility, acceptability, and quality, but also include the adoption of preventive measures. And these preventive measures, the court explains, use the PAHO, some PAHO standards to say that the prevention measures should imply some primary prevention measure, for example, protect people before something happens. Secondary prevention measures, for example, take care of the people and make some diagnosis when there is some suspicion that something is happening. And also tertiary prevention measures, which is actually taking care of the people, rehabilitating and reintegrating these people into workforce. Obviously, none of these actions happening in real life, and therefore the court found the state of Honduras responsible for the omission in the duty to prevent these disabilities to happen. So just to close and probably to conclude, very important is jurisprudence of the Inter-American Court from very from the very beginning, from the 2006, obviously including some specific additional duties, but I think that is a good way to start making some clear obligations regarding to private providers of health services, which, as Alicia mentioned at the beginning, is very often the case in most of the Latin American countries.
Okay, thank you so much. And I'm so glad we got you back to finish the presentation. So now I will go back to the questions in the chat. And the first one from an anonymous attendee is that it's remarkable to see the clear jurisprudence from the court with regard to the right to health is autonomous. Kindly share some light with regard to the establishment of the right to health in the jurisdiction of the court, international law, constitutional underpinnings, or statutory inference. And I think Christian already began to do that. So I will add a question that I think is important for you as listeners to understand the kind of dialogue that goes on between conventional control and constitutional control, between national courts and the Inter-American Court, and how there's sort of a recursive relationship in constructing the meaning of rights. So, for example, Liliana mentioned how important Octavio Murillo was in the Argentine abortion struggle because anti-abortion people had often pointed to Article 4 of the American Convention as protecting the life from conception. And after the Inter-American Court said that no, that is not true, it's progressive, etc., that changed the frame for the debate at the domestic level. So I'm wondering if Christian, or really all of you, could add a little bit and answer the question in the chat.
So a few ideas on that. I mean, one, again, a comparison with other similar systems, as I said, neither the Human Rights Committee or the European Court of Human Rights have been so progressive, so evolutive in terms of reading positive obligations around the right to life and personal integrity. So even the jurisprudence before this turn on Article 26 was very progressive, and even not mentioning the right to health and saying that there was a violation of the right to life or the right to personal integrity, the court used the general comments, particularly General Comment 14 of the Committee on Economic, Social, and Cultural Rights, bringing the criteria for interpretation developed by the committee, particularly the AAQ and other ideas. So that's even before using Article 26. So that there are many criticisms on the use of Article 26, saying this was already achieved before bringing Article 26 to the issue. And before using Article 26, there was no discussion on progressive realization or immediate obligations. All obligations were seen as immediate. So this was a step backwards, some critics said. On Article 26, there is a clause in the Convention on Economic, Social, and Cultural Rights. So one of the issues that the court did not do before 2016-17 was trying to interpret what this reference to the OAS Charter meant. What are the rights that are implicit in the economic, social, and cultural norms of the OAS Charter? And the court offers some methodology to do that. So it says we need some textual reference in the OAS Charter, and it tried to do that for different rights, for the right to health, for labor rights, for the right to social security, among others, but has not always been very consistent on that. So in some right to health cases, it uses some of the clauses of the OAS Charter. In others, it says it is an implicit right. So there's some lack of consistency there. Usually, the way the court has packed this was first finding a textual reference in the OAS Charter and then going to the American Declaration of Human Rights, of the rights of duties of men, that includes the right to health and other rights. So that's a way to confirm the textual reference of the OAS Charter. And then another layer has been the idea that most of the national constitutions in the region recognize the right to health. So usually in the analysis, country by country, the courts, another instrument that I was mentioned is the Protocol of San Salvador, that even under that instrument, the right to health is not a justiciable right. It's a source of recognition of the right as a right that should be protected under the American Convention. And as I said, in the country by country analysis, there's a general recognition of a trend in the region of recognizing the right to health as a fundamental right, and then an individual assessment of the way in which the right has been enshrined in the national constitution in the country at stake. So that's a bit how the court has found legal foundations to develop the jurisprudence on the right to health. There are many questions and criticisms to the court on saying the standards they use to identify right are very vague and loose, and actually most of the cases of application of Article 26 have dissents, and some of the dissents are exactly on this point, saying there's no clear mandate by the framers of the Convention on using Article 26 as a vague way of reading other rights in the OAS Charter. So as I said, we will see what happens with this new composition of the court on this particular point. Over.
Did others have something to add to that? No? Well, why don't we go to some other questions? There are a couple of questions about how the court has addressed migrants' rights in the region, access to medicines and other health access. So that is really to any of you.
I can answer.
Liliana.
Yeah, perhaps I don't remember well, but perhaps the court don't have or doesn't have a case about specific about migrants and right to health. Perhaps the exception is the case about IB, the woman who was forced sterilization in Bolivia. But the court show in different cases a big conception of discrimination, and perhaps this conception of discrimination can help us to take a position about this question. The court I think that the court, in case of migrants or undocumented migrants, or in context of migration, the court recognized and presumed the situation of discrimination of this group, and recognized the right to health or the right to essential medicines in the case.
So I'll take the liberty of adding a footnote on that. I think that case is interesting in the way the court deals with refugees and immigrants, in that it does not see evidence that this poor Peruvian woman was discriminated in the access to healthcare, but in the access to remedies. The intersectionality of her poverty and her refugee status, as well as her gender, are all brought into the court's analysis of the case. So I think it's actually a very interesting opinion. The question of migration has come up in constitutional courts, of course, across the region, especially in the Colombian constitutional court's jurisprudence. But I don't know a lot of other cases on migration or refugee status, but I'm happy to turn it over to Diana.
Yes, exactly. I just wanted to mention there is not so much in the Inter-American Court, but the Constitutional Colombian Court have developed some standards to say that migrants, regardless their legal or illegal status, have the access, have the right to access to some life-saving medicines and treatments. And this has been something very, very important in the context of migrants from Venezuela, around 1 million migrants who are actually living in Colombia. So most of them, as far as they can prove that the medicine or the treatment that they require is something necessary to keep their life, then can access to health services. This can be difficult, for example, in the case of chronic disease, because in that case, for example, if you need some insulin, then it's difficult to prove the connection. But there are also some cases in which for chronic disease has been allowed to some migrants to access to health services. There are also other jurisprudence about, for example, women asking to have their birth in Colombia, or something related to the protection of children, migrant children in Colombia. But I think it's very rich jurisprudence, and it's something to keep in mind, and hopefully it will, in the future, illuminate the Inter-American jurisprudence.
Mm-hmm. So for my side, I mean, two important references in the Inter-American Court, not on health, but on ESC rights. One is the Gina and Bosico girls versus Dominican Republic case, which is a case about migration status, nationality status. These were two girls born in Dominican Republic, but from Haitian descent, and they were denied nationality. So that impacted on a series of rights, including the right to education. So there's a finding of violation or of the right to protection of the child, including on the right to education. And then the other competence the court has is consultative opinions, and consultative opinion 18 on migration, on undocumented migrants, particularly applies to labor rights, but the court says that non-discrimination is a jus cogens principle and applies all over the board, the principle even on the basis of migration. So there's a good foundation there for future cases. And the Argentinian Supreme Court has also some jurisprudence on the idea that conditions of residence might be disproportionate, particularly long resident terms as a condition for social protection schemes. So it declared unconstitutional a scheme that required 20 years of residence to be eligible for a social protection scheme. So these are other developments that link access to benefits and socioeconomic rights with migration. Over.
Laura, did you have something to add?
Yes, I would like to say something about provisional measures and right to health of people that are detained in migration stations in the Tapón de Darién. I don't know how to say in English.
Yeah.
Yes, and I think that in those provisional measures in the frame of the case Vélez-Lur versus Panama, I think so, then the court order, Vélez-Lur, the court ordered the state to provide food, water, sanitary equipment to prevent spread of COVID, and also to guaranteeing the right to health. So I think that this is something important because the court is developing some maybe jurisprudence, not direct in the case law, but in the frame of provisional measures. And this is something that maybe it's not, how can we say, taken into account in the academia in general.
That's really a fascinating point. So I want to turn in the last few minutes to be a little bit more provocative. We've heard about really the very progressive, as has been repeatedly underscored, jurisprudence, the different spheres in which the court has acted, the reining in of corporate enterprises and private actors in the health system that is extremely prevalent in the region and the world. And I want to kind of challenge you all, because there is a gap between that quite bold jurisprudence, even where there are the court has missed opportunities or not gone as far as we would like, etc., and not just the material impact, direct and indirect on the ground in terms of what we would call the effective enjoyment of health-related rights, especially for the people who are impoverished and excluded. And I'd like to hear your thoughts about the sources of that gap and also strategies that we might use to overcome it. So I'll start with you, Christian.
Yeah, I mean, obvious answer is, I mean, the court decides case by case. Cases take 15 to 20 years from the deeds to the moment of decisions of the court. So the court does, in this sense, what it can do, and the idea that of developing a sense of not only reparations and material reparations, but also guarantees of non-recurrence has been important in terms of at least trying to prevent future occurrences of the same violations. But as it happens with any judicial system, it's piecemeal work depending on the kinds of cases that arrive to the system. So I would say some of these standards can be important, particularly if taken back to the national level to lobby, advocate for a public health system that is strong enough and universal, etc. So, it gives some signposts which are important, but rarely it's 10 or 15 cases where it will change the very unequal reality, socioeconomic reality, and the way in which the fragmentation of health systems in Latin America work. So I think the decisions alone are, I mean, they are nice pieces of jurisprudence. Some can be criticized or not, but are interesting, at least challenging. But I think they need to be taken back to the national level to discuss what's the legal and practical framing of health systems and identifying which are the gaps in countries and advocate for something slightly more fair.
So how can we bring those decisions back, Liliana and Laura and Diana? How can we make them, how can we translate beautiful jurisprudence into more, into institutional practices and structural conditions? Diana?
Thank you, Alicia. I think that the problem that you highlight is very serious. Probably is related to the fact that the decisions of the court are separate from these political scenarios where the states are actually discussing what are the role in terms of the Organization of American States, what are really able to comply. The political decisions happen in one side and the judicial decisions happen in the other, and there is no way to connect that or to make that connection. This is probably different to what happens in the European system. As far as I understand, for example, in the decision of pilot judgments, it's very often that the court is negotiating directly with the state, and that creates, in a way, more participation and anticipate and make sure that the decisions are going to be compliant. So that's one thing to say. For the future, what I see in the future of the court is try to use this jurisprudence, this inter-American jurisprudence, and to make it replicable by domestic judges. I have obviously faith in the inter-American system, but also in the domestic systems, and that they are able to replicate and to really make an impact in most of the cases. It's impossible to bring all the violations of human rights that are happening in the Americas to the inter-American system. It has to be used as a way to create general standards, and then it's up to the domestic judges to implement them.
Liliana, did you want to add to that?
Only one point. I agree with Christian and with Diana, and for me, in this point, it's very important the publish the standard of the Inter-American Court, not only to comply with the sentence, because it's important to prevent violence in the region, in our countries. Perhaps we need to enforce the human rights education in the person who are studying law, for example. It need to enforce the standard of the Inter-American Court, and not only what happened in the court, so what happened in the commission, because a lot of cases arrive to the commission and finish in the commission, and the standard that the commission creates are very important too. So only this point.
Yeah, no, that is an excellent point. Maybe you could just say a word about how the Inter-American Commission works with the court. I think Christian touched upon this, but because it is different from the European system, if people are familiar with that. Or sorry, I don't mean to confuse you. I can do it. So you bring a case after exhausting domestic remedies or showing the futility of exhaustion to the Inter-American Commission, which then there may be precautionary measures, there may be some other friendly settlement resolution, and the commission then takes the case as kind of like a sort of public prosecutor is a party to the court. It refers it to the court. That is different from the European system of human rights. The Commission also holds hearings on a variety of different thematic issues. It has rapporteurs, as the UN system has rapporteurs. So the Inter-American Commission is an extremely important actor in the whole system, the Inter-American system of human rights. Laura Clerico, I think
Well, maybe I would like to come back to your
yes, absolutely. I'll give you the last word on how we bring this jurisprudence home.
Well, I agree with Christian, Diana, and Liliana, but maybe I would like to come back to something that was said by Liliana during her presentation, because Liliana highlighted that the standards that were developed, and I think you also, Alicia, were developed in the case Artavia Murillo versus Costa Rica, about were very, very important to advance the discussion at the local level about the permission of abortion and so on. So, and then this was, these standards in some sense were adopted by political movements so as to frame the fight for the permission of, to gain the permission of interruption of yes, to gain the or to derogate the prohibition of abortion and so on. So this is, I think this is key, because we as lawyers have a mission to translate in easy words, but at the same time, we need these alliances with political movements, maybe also with political parties and so on, so as to make these standards part of the, how can we say, parts of the claims, not only legal claims, but political claims at the and on the streets and so on. That's, I think, but at the same time, we need that, we need some influential groups also take as part of the political agenda the thing related to the regulation of health sector, because otherwise it's very difficult to transform this structure that put in a position of structural disadvantage to poor communities. That's why my first thesis. If we don't take into account the thesis that structures of the health sector reflects social structures, maybe we were not discussing the main point. And I think this, only to close my opinion or my statement, I think that we need to search more about the function of the Inter-American Court and in the Inter-American Commission, in the sense that for some groups and for some victims, this is a space to make these structures visible, because at the local or national level, they don't have the possibility to be heard. So I think I stop here.
Well, that is a fantastic place to stop, and I could not agree more. I think that all of the presentations have highlighted the kind of recursive nature of the dialogue between what happens on the ground with constructivist struggles for rights, as well as the Inter-American Court and the Inter-American Commission, as well as institutions that function as interlocutors, but in a dynamic process that is in constant evolution. It's inaccurate, in my view, to separate out the supranational actors and jurisprudence from what we see, the concepts and the ways that those from the conceptualizations and to use Sally Mary's term, vernacularization of rights on the ground. So I see it as really being as being quite recursive, and of course needing to catalyze political action at the national level, which sometimes does not happen fully with the judgments of the Inter-American Court. So with that, I'm just going to come back and re-thank all of the incredible panelists that we've had for their insights and deep knowledge about how the Inter-American system works and the kind of temporal timeline in building out jurisprudence on rights as well as interdependent and related rights, and sharing their personal views as well. And thank again the co-hosts for this event and my colleagues, of course, at the Petrie-Flom Center, Laura Chong, Chloe Reichel, and Carmel Shachar. And with that, we will close. Thank you very much for all the participants who attended.